Good evening, everyone, and many thanks for joining us. I'm Megan Donaldson, and this is Professor Paparinskis. Welcome to this conversation about the International Law Commission, or the ICC. I think quite a number of you are students, and you're probably familiar with the ICC primarily from its work product. Things like the Articles on Responsibility of States for Internationally Wrongful Acts, all the groundwork and drafting which went into instruments like the Vienna Convention on Diplomatic Relations and the Vienna Convention on the Law of Treaties. And many of you might know that the ILC currently has on its agenda some quite significant and quite controversial topics, from immunity of state officials, from foreign criminal jurisdiction, to international legal aspects of sea level rise. But for all its ubiquity, its presence in all these different areas of international law, the International Law Commission as a name is a little bit generic, even mysterious. So what we're trying to do tonight is really zoom in on the ILC as an institution. So what it is, who serves in it, how it works. And this process of zooming in closely on the way this institution works might help situate or sharpen questions about the ILC in a larger landscape of sources and processes of making and changing international law over time. And we do have time for questions at the end. We would love to hear from students, from lawyers, from everyone else here. So do please think as you're listening whether there are lines that you'd like to take up with Professor Paparinskis. We are very fortunate this evening to have with us someone who can speak from the inside, as it were. So Professor Paparinskis will be known to many of you, generalist public international lawyer with particular interests in things like investment law and international adjudication. And crucially, someone who was elected in 2021 as one of the 34 members of the International Law Commission. So with no further ado, I'm going to invite Martins to tell us a little bit more about the very basics of the ILC, when and by whom it was established and to what end.
Thank you, Megan, and delighted to be here for the second time. When I was last year the chair of the drafting committee, the informal practice I adopted in describing the views of the members was that if something happens 3 times, it is an emerging trend. So we're not quite yet at an emerging trend, perhaps next year. So International Law Commission is something that was founded by the General Assembly of the United Nations. I'm holding a pocketbook version of the United Nations Charter. Article 13 says the General Assembly shall initiate studies and make recommendations for the purpose of A, promoting international cooperation in the political field and encouraging the progressive development of international law and its codification. That is the second part, encouraging the progressive development of international law and its codification that provides the legal hook for us. So on the basis of that, the General Assembly established the so-called Committee of the 17, on which a very interesting recent article has been written in the Leiden Journal of International Law. And on the basis of that, in 1947, the General Assembly adopted a resolution creating the International Law Commission. And this is a very opportune time to discuss it. The anniversary was a very recent one. The resolution was adopted on the 21st of November. So that is the sort of the creative context. The General Assembly has been given a mandate. There was quite a bit of discussion about where and what sort of body International Law Commission should be, particularly regarding the closeness between the International Law Commission and states in the General Assembly. States in the General Assembly obviously speak, as it were, on their own behalf. There's nothing wrong about that at all. That is the character of the General Assembly. Within the International Law Commission, members are participating in their individual capacity. So they may be, as it were, in their full-time job, a legal advisor of the Ministry of Foreign Affairs, but within the International Law Commission, they do not speak for Russia or Ecuador or United States. They speak as individual members. And that is an important distinction in lots of places of the international legal architecture. That is a key distinction where whether, it may well be exactly the same person, but whether their hat is that of an individual expert or a state representative, whether they are mouthpiece of a state in a descriptive, not pejorative sense. ILC in that sense is independent, so one might think of it as probably not a term that people would have used in 1947, but a think tank of the General Assembly. So perhaps a more recent, but a fairly apt phrase.
And so this think tank, which is now comprised of 34 members, speaking in their individual capacity, how is it composed? How is it constituted? Where do the 34 come from?
Yes, so the 34 is the current number from 1981. Initially, the International Law Commission had 15 members, and then there were a number of resolutions expanding the membership, eventually ending up with 34. As with many other things in the United Nations, International Law Commission reflects the division between the regional groups. Regions are drawn differently in different international organizations. Within United Nations, there are 5 regional groups, Western European and others group, and others are US, Canada, Australia, New Zealand, Eastern European group, African group, GRULAC, which is the group of Latin American Caribbean states, and Asia Pacific states. So that is the, essentially, I suppose, the regional groups that were formed at the very early years of the Cold War, which do not really reflect the contemporary political realities. But an important element of United Nations is that if something works, even if unreflective of reality, you don't break it because you don't know who would benefit when it's put together again. Perhaps was a slightly deeper point than I intended there.
Please continue.
One interesting thing to say here about the statute is that Article 9 of the ILC statute says that about the candidates up to the maximum number prescribed for each regional group who obtain the greatest number of votes shall be elected, and that is an amendment in 1981. Before that, there was also a division of membership between regional groups, but that was something that was following not from the rule in the statute, but from established practice. And the peculiarity of established practice, as you know, it is established until it is not, because formally speaking, it is the votes that count. And it could be that the boundaries between established regional groups are redrawn in the context of the International Court of Justice. United Kingdom appreciated at that point 7 years ago. So within the ILC, that sort of practice cannot happen. So the regional competition is entirely intra-regional. So it may be that the competition is fairly low in one region and fairly high in another region. So that, I think, is an interesting point, so thinking about similarities and differences between the International Law Commission and International Court of Justice. Similar in some ways, because both of them are elected by the General Assembly, but ICJ also has the parallel election by the Security Council. That was something that was discussed as a possible option for election of the ILC as well in the early years, but the General Assembly concluded that there was an important distinction, that it was more of a General Assembly body, subordinate organ of the General Assembly, which makes, I think, good sense. That is what seems to follow from Article 13A. And also, I think that is also an interesting point in thinking about institutional architecture, the sharp division within the ILC versus sort of the floating boundaries in the ICJ. That's perhaps a discussion to be had in 2 years.
So it's quite an interesting and complex idea of representation. We have individuals speaking not for their states, but in their independent capacity as experts in international law, elected in these sort of intra-regional competitions, which might be more or less intense depending on the regional grouping. And also, I suppose, in theory, bringing some kind of knowledge of distinctive legal cultures, which might map well or poorly onto the regional grouping divisions depending on the grouping. I wonder how that quite complex picture of representation intersects with the sorts of discussions we have today in other international legal institutions about diversity, representation. You know, you refer to the ICJ. I teach international criminal law, so I'm quite mindful of the International Criminal Court example. And that's a sort of fairly groundbreaking requirement that states parties have to take into account fair representation of female and male judges. Quite what that means, up for debate. But it seems that the ILC hasn't moved in the direction of those express stipulations. Is that right?
That is absolutely right. So sort of what ILC is getting at in terms of, so that I think perhaps really the productive tension between diversity and generality is captured quite well in Article 8. So it says, at the election, the elector shall bear in mind that the persons to be elected to the commission should individually possess the qualifications required, and that in the commission as a whole, representation of the main forms of civilization and of the principal legal systems of the world should be assured. And what are the individual requirements? Well, Article 2, Paragraph 1 says that the commission shall consist of members who shall be persons of recognized competence in international law. So there's an element of circularity, because how do we recognize them? We recognize them by the fact that they're elected to a body that has members who are people of recognized competence. You're right that so the language of gender diversity does not appear in the International Law Commission statute in the way how it does in other settings. So International Criminal Court and European Court of Human Rights has adjusted its procedures in the last decades. But that is an important issue that is being discussed. I just again looked at the resolution on the report of the International Law Commission on the work of its 75th session that the Sixth Committee adopted by consensus last week. And paragraph 12 recalls essentially what I quoted, as well as invites member states to bear in mind General Assembly Resolution 77335 concerning working methods of the Assembly and its subsidiary organs when nominating candidates for the Commission. Now that might sound a bit dry for those who are not keeping all of these resolutions on your tables, but within that resolution, a reference is made to gender diversity. And it's interesting that after this resolution was adopted by consensus, the representative for El Salvador took the floor and she said, by reference to this resolution, notes, and I do apologize in advance for my spoken Spanish, en el contexto y propósito del párrafo subraya el esfuerzo por el que se busca incentivar la presentación de un mayor número de candidaturas de mujeres para ocupar puestos en los órganos subsidiarios. Por ello, alentamos a los Estados miembros a continuar fortaleciendo esta práctica y tener esto en mente al momento de nominar candidaturas para la composición de la Comisión de Derecho Internacional. So the idea that that is something that is normatively something that should be taken into account in elections to the International Law Commission, as well as in other settings. And that is something that Secretary General, when calling for nominations, also referred, so probably to a previous iteration of the same proposition.
Can I just say parenthetically how much I appreciate your full embrace of the material proofs of textual commitment, including linguistic diversity, your close attention to the texture of language. We'll come to this.
Yes, I think multilingualism is something that, a fuller appreciation of the wonders of multilingualism is something that I have taken away of, it's always better in Arabic.
Okay, well, much more to plumb here, but I wondered before we get to the kind of experiential side of it, what it is to work in this way with these colleagues, whether you could just say a bit more at a high level about what kinds of issues the ILC has been dealing with in the last couple of years since your election, and maybe what's immediately before the IOC on the horizon.
Right. So looking at this year's report and sort of moving in terms of things that are, as it were, the most recent on the agenda, and then proceeding in the direction of those that are closest to the conclusion. The most recent topic is the topic of non-legally binding international agreements, and I use this term descriptively rather without indicating approval of agreements as a proper term to address the issue, but that is a topic for which the first report was introduced this year by Special Rapporteur Matthias Forteau, so as preliminary exploratory topic.
And if I just sort of translate a little bit for people who might be less immersed in the technicalities of this, I think what's an issue here is the way in which law intersects with a class of things which the British tend to call memoranda of understanding. So agreements which are in writing, often quite detailed, but which are expressly not made as treaties subject to international law. That's right.
That is absolutely right. And I think that this is something that states take very seriously. More and more as it, in a broad sense, international relations work takes place in this manner, both for good reasons and possibly sometimes less good reasons. And so this topic would be looking at, I guess, both trying to draw the line when, as it were, the point where bindingness appears, which is something that different states may be drawing in slightly different ways. And so if one looks at the comments by the states in the Sixth Committee, and sort of we'll probably get at some point how that, where that fits in the picture, but just simply say that in the most recent discussion, many states were expressing their concerns about the fact that the topic is entitled agreements. United Kingdom, for example, took a very strong view that for a long time it had used the operative terms agreements and agree precisely to indicate those documents that fall on the binding side of the ledger. So that is very important, distinguishing what is binding and what is not binding. That has important implications at the level of public international law, important implication at the level of domestic law, possibly where that fits and under what constitutional procedure. And the general, so the second theme, I suppose, of why that is legally relevant, the fact that they're not binding doesn't mean that they cannot have legal implications for other things. So, for example, for the purposes of interpretation of treaties, at least the International Law Commission has taken the view that a subsequent agreement for the purposes of interpretation, which can be hugely important, need not be binding. So in a sense, the fact that something is not binding is it doesn't create legal consequences on its own, doesn't mean that another legal regime could not attribute to it legal consequences. Think around the litigation, for example. So that is something that, ILC is just at the very beginning of the process. Then there are three topics that started last year. Well, let me start with the one which is perhaps closest in some sense to what we talked about. Subsidiary means for the determination of rules of international law, which ILC is engaging with under the special rapporteurship of Charles Jalot. And subsidiary means is something that International Court of Justice statute has in Article 38(1)(d) when it lists in ABC treaty custom and general principles, and then it says, and subsidiary means for the determination of rules of law, such as judicial decisions and writings of highly qualified publicists, again, French, which I think as many colleagues would say is better, it simply says la doctrine. So what does that mean? Are these things exhaustive? Would work of human rights committees, for example, fall within that? Would the international law commissions work? How do we evaluate these matters? So, sort of very practical questions. So, I mean, I would imagine that when next week many states go to the plead before the International Court of Justice in the advisory proceedings regarding climate change, questions of how much weight should be given to resolutions on human rights and environment, or on the earlier advisory opinion of pit loss, those would be sort of things that are very important for practitioners. Another thing that also started last year is the topic on settlement of disputes to which international organizations are parties under the guidance of August Reinisch. And there, sort of probably the case you might have read about and heard about is the Haiti cholera dispute, where United Nations peacekeepers in Haiti were credibly alleged to have brought infectious disease, the epidemic of cholera, to Haiti. And the question was whether there was a context where the victims could ensure accountability, whether that would be in the domestic courts or another setting. United Nations invoked immunity before domestic courts, and ultimately there was no setting where these claims could be litigated. So that is a sort of the question of trying to figure out whether there are overall concerns about access to dispute settlement. And that is something that ILC will actually be looking at next year. So far it has been looking at perhaps the important but perhaps somewhat less exciting aspects of dispute settlement of organizations with other organizations and states. And then the third topic that also started last year is on prevention and repression of piracy and armed robbery at sea, which was led by Rapporteur Jakub Asise, and now is led by the second Special Rapporteur, Luis Savadogo. It's a very classic topic of public international law, and probably there the intuition is that there is quite a lot of international law on this issue in the United Nations Convention of Law of the Sea, and incidentally in criminal justice cooperation law, but it might not perhaps be fitting together entirely neatly. And I know that I'm coming with quite a lot of things here, but just to sort of to get out what is, in a way, the sort of the sense of jumping from different parts of the international universe is precisely right. That there might not necessarily be a logical rhyme that they fit together in a certain way, that they are a bit random and decentralized, and the punchline would be just as international law is. So these are things that we are sort of have commenced just now. Then there are also certain topics that have been going on for a bit.
Maybe we can populate this decentralized landscape at a high level, and then we can people can come back. If you just can give us a tour d'horizon of what else is there.
Sea level rise in relation to international law, something that is going to conclude next year. So that is something that particularly small island developing states are looking forward with a great deal of interest, considering the extent to which climate change related sea level rise, so it's a narrow topic, relates and affects the law of the sea, statehood, and human rights. So that is sort of one thing that has been penciled in to end next year. Another is the topic on general principles of law, sort of something that probably again kind of fits more in that part of the tapestry where subsidiary means and non-legally binding agreements, where sources, the third source, 38(1)(c), which will be worked on in the second reading next year. And just sort of as a sidestep, the first and second reading is the way how ILC does things. It sort of works through their topic until it has adopted as many provisions as it considers fitting, then gives it to states for 2 years for reflection, and then returns for the final second reading adoption. Another thing that will be continued in the second reading is a topic that you mentioned as a particularly contested one, immunity of state officials from foreign criminal jurisdiction, which was commenced this year. And another thing that is also penciled to end next year is the topic of succession of states in respect of state responsibility, which was led by Special Rapporteur Pavel Sturma in the previous quinquennium, who was not elected to this quinquennium, and there has been a decision taken by the working group on the topic with a narrow mandate to finish the work and sort of summarize in a report. I think the phrase is difficulties that this topic has given rise to, and this is read by Bimal Patel, the Indian member of the commission. And so sort of these are kind of things from our just glimpses of things to be to things that are almost finishing. And I think the immunities topic is probably something that began sort of 2007, 2008. So these things can take quite a long time. General principles sort of is probably a sort of a shorter one. So there isn't a necessary rhyme that a topic is something of that sort that takes that sort of time.
I mean, as you're speaking, you have, I think, a sense of the range of kinds of topics that are engaged, from the very sort of not technical topics, but let's say topics which go to the way in which we reason as lawyers, the way we work with sources, the way we work with documents. Then you have a sense of the omnipresence of violence, the risks from nature, the risk to the individual, questions of accountability, and so on when we come to dispute settlement. So it does cover international law, I think, in all its richness, both the long-standing questions and the quite immediate questions, the ones which may not have been on anyone's radar 10 or 15 years ago, with sea level rise, for example. I wanted to ask a bit more about how the topics are chosen, sort of how they emerge to the surface, but perhaps we can get to that in the Q&A and move to talk in a bit more detail about how the ILC works intellectually. So you've mentioned that there's in a sense, a first and second reading stage, which is a sort of structured dialogue with the sixth committee. So it's the ILC is constantly working with states and inside that UN structure in processes which can extend over a period of years. But I wondered if you could say a bit more about, in a sense, the acute work that you do when you're a member of the commission, or particularly chair of the drafting committee. So I have heard you say before that it sometimes takes you, a couple of days to get through a couple of lines. So I wondered if you kind of give a sense of what you're doing when you're doing that work, in what languages are you working, and what is it that creates that complexity? So what's at the heart of why it takes so long and is so painstaking?
Right. And so I think it would be perhaps good just to take through the yearly cycle.
Yeah.
At some point, probably at some point in February, the draft reports in one UN working language will start dropping in, and they will be shared with ILC members when they do. They can be prepared in any of those languages. It can be English, French, Spanish, but the Special Rapporteur Kolotkin, who was the first Special Rapporteur on immunities, prepared his reports in Russian. They are not shared publicly, because for things to be shared publicly, they have to be translated first into all United Nations official languages. So what we get in February, the broader world, sort of the broader world that is interested in ILC work, would read in sort of April, May. In many ways, I have to say that international law works the way it works because of the UN translation services. I think in some ways that is the most important part of the mechanism by reference to which progressive development and codification are judged. So for a couple of months between February and mid-late April, when the plenary session in Geneva starts, I think probably different members work differently. I think usually there is sort of a degree of cooperation with research assistants, particularly if topics are so diverse. Probably very few people would be experts in absolutely everything of those aspects that were there. I think that, different people work differently. Some have assistants relating to particular topics. Others have, things relating to the overall work. Then when we get to the Geneva, plenary session starts, and usually what is prioritized are the topics that are furthest ahead. So it's likely that, second reading is the one that is furthest ahead. Then there are plenary sessions, and members make their plenary statements that they have pre-prepared. So, possibly not the most exciting process. People read out their statements, but there's a certain degree of intellectual excitement and probably more entertaining for those who are not special rapporteurs, because it's often that this is a point where the ILC members don't really hold back, that if they think that something doesn't make sense, that is what they will say. So it's really very, particularly because there are other bits that are very formally diplomatic, there's always, as Madame so-and-so and Mr. so-and-so and such. So there's a great deal of intellectual frankness of what one thinks about the project. 20 minutes, which is recommended time that some members follow more closely than others. And then after the process works through, the special rapporteur makes concluding remarks and sort of says, well, this is what I heard, this is what I was proposing. I heard, there seemed to be consensus in that regard. I will somewhat adjust what I'm proposing. And with very rare exceptions, none that I have seen so far, then the proposed provisions, because it's usually that there's a report with certain proposals of what to be adopted, is referred to the drafting committee. Drafting committee sessions are closed, although research assistants can witness them, and that is where probably really the sort of the thing where one sentence being worked for 3 or 4 days appears. That is really, the provisions themselves are really reflective of a great deal of high quality of discussion. Ideally worked on in 3 working languages, English, French, and Spanish, which contributes both the legitimacy of the process, as colleagues underline in various settings, and also to the quality of legal reasoning, really, so testing out whether certain intellectual and drafting suggestions work or do not work in different languages. So that is a very, very interesting, I think that is, the fact that it's closed perhaps again contributes to the frankness of the discussion. What we do know about it is what the chairperson of the drafting committee says in their statement after when it goes back to the plenary. And then it is summarized in somewhat anodyne language of issues that were discussed, what the consensus was in the end, what other ways might have been adopted. And that actually strikes me as perhaps really the most interesting part of the bit, where one sees what ultimately prevailed, but that there is really no necessary inevitability, that there were certain plausible points considered, and it might well have been that another would have been adopted, but what was adopted was the thing that did capture the consensus of the committee.
So this point about consensus is interesting because the ILC does primarily work by consensus, even on issues which might be ones on which states take quite different views. And unlike some other international law bodies which work by consensus by not doing very much, or by saying things in ways which are very, very ambiguous and can be taken by different interlocutors in different directions. The ILC does do quite a lot, and with this attentiveness to precision of language. So there's something quite particular about the approach to consensus, or about how consensus is attained in this environment, perhaps, which is in this artistry with language and the time that's taken. Is it what you expected when you went into?
I have to say that what struck me is really that broadly shared sense of belief in a ILC project. I mean, it sounds a bit of a strong statement, but that there is a value in international reasoning of this sort, that it's worth for people who might be at the top of legal professions in their countries, legal advisors, or an occasional minister of foreign affairs, to spend 10 or 12 weeks of their busy schedule there, actually going line by line over such issues. It also sort of reflects that odd strength of being independent, at the same time independence within the broader fabric of the General Assembly and the much broader fabric of the United Nations. So sort of a sensitivity to the broader political process and where the added value can be done, in a sense of looking at the way how technical legal reasoning can adjust that and reach it. And really, a great deal of legal imagination of papering over the cracks and finding just the precise language that, captures certain things.
Okay.
But then it's also possible, after something has been adopted, to take the floor again and indicate that, while one didn't object to break the consensus, one is still unpersuaded. So there's a little subtle ways of indicating ways of disapproval. And that's sort of, if I can just jump ahead and kind of just sort of, it's ways of hinting to states of what points might be still up for discussion, that this is a part of the bigger legal process. So after the drafting committee comes back to the plenary, it's usual that what is suggested is adopted, but sometimes members explain their understanding and remind the chairperson of the drafting committee that their recollection of something was not entirely in line with that. It's quite often that linguistic issues are raised in that setting. And so, then the same thing sort of happens with other things. And then in the last 2 weeks, as a matter of general adoption of the report in the plenary, commentaries are adopted as well. So that, I have to say, is one thing that has really struck me, thinking about the weight and value that one gives to sources. Commentaries are important, and they are often of very high quality, but I wonder whether we might have been perhaps a bit spoiled by the ILC work on state responsibility, where commentaries are really gold standard, and in many sense, particularly in part one, those were commentaries that were probably finessed for some 30 years. There are settings where commentaries are perhaps not quite finessed for 30 years, and that might affect the way how we think about their weight in interpretation, application, and different people have. There's a famous article by David Caron in the American Journal where Caron said that he thought that, you have to start with the commentaries because that is a more elaborate version, and then, the provision just captures them, however imperfectly. And Giorgio Gaia pushed back at that a couple of years ago in the British Yearbook, where he said that, in a sense, you treat them with an eye to the intellectual effort that could have been invested in them, that provisions you treat with utmost seriousness, and if they don't make sense, one is perfectly justified calling it out, and if they do make sense, attributing a great deal of weight to it. Commentaries perhaps a bit more lightly, and that strikes me as in line. So, advanced version of the report is published in mid-August. possibly not the best time for legal advisors' offices to start working on things, but that is how it is. And then in late October, for 2 weeks, the Sixth Legal Committee of the General Assembly discusses them in New York. And so that is, you know, they have all read the reports. Some comment on all the chapters, some comment on certain things, some don't comment on anything at all. Again, I think states are quite frank about it. If they like something, they say it. If they don't, they say we don't understand it, or it's not in line with our understanding of state practice, or we suggest that it is reconsidered and deleted. So states are robust and lively in their views.
So one of the things that has happened quite recently in the Sixth Committee is that there was a, I don't want to say unexpected, but to some people unexpected embrace actually of longstanding work of the ILC on crimes against humanity. In particular, we had not anticipated perhaps that there would be so rapid and consensual a move towards taking the ILC's work and putting it into the basis for a conference of states, which might ultimately lead to a convention. So this, in a sense, represents quite a success for the ILC in terms of the way in which states have responded to it.
Absolutely, and I think that is, and I think it's really worth reflecting upon it, because pretty much since sort of late afternoonish last Thursday, so again, this is well timed. We have to rethink certain assumptions about, you know, what succeeds in ILC and what ILC does. For a long time, the short and unkind line of the Sixth Committee was the one promoted by Sherpa Suarez, the previous legal advisor of the United Nations, who described Sixth Committee as a graveyard of the ILC products. That is where ILC products are sent to die. So, you know, ILC recommends that the Sixth Committee takes certain action, and, you know, then they would return to it every couple of years ad infinitum. That is different since last Thursday. And yes, it is absolutely right, as Megan said, that for the first time since 1994, so we're really going back sort of to the convening of Rome Conference stuff, there is a recommendation, this operative paragraph 4 decides to convene the United Nations Conference of Plenipotentiaries on prevention and punishment of crimes against humanity. So again, not something that was necessarily expected. There's a great deal of debate. This was a decision that was reached by consensus. If you look at sort of the thing that is on the website was orally revised. So, you know, if you're real aficionados of Sixth Committee, you can sort of follow all the day's debates there. And I think, you know, Mexico, that was one of the co-facilitators of the resolution, is took a particularly strong view and played a particularly important role together with Gambia. So it was an orally revised one. So compared with the original draft, the timing has been pushed a bit further. So the original draft was to have the conference in 27, 28 and be quite inclusive regarding the participation of non-governmental organizations. And the all revision moved it 1 year further down. So the conference will be in 28, 29. The preparatory committee will not be in 26, but in 26, 27. And there will be access to relevant non-governmental organizations that have consultative status with ECOSOC, but the provision on sort of the broad inclusion of NGOs was deleted. So it was a somewhat more ambiguous language. So that is important. I also note possibly a bit less of a front page news, but also a resolution was adopted on draft articles on protection of persons in the event of disasters. where the Sixth Committee decided in principle to elaborate and conclude a legally binding instrument by the end of 27 at latest. I mean, there's a operative paragraph 5, which might add a bit of a wrinkle to that, but I think that's right. And I think it's sort of, it's an interesting, and we have spoken about sort of what the bigger takeaway about is, perhaps degree of caution about takeaways, because we have a relatively limited number of products, each peculiar in their own way, each falling in a particular political context and political time. So I don't think that anybody could necessarily have predicted that these things would really fall, you know, precisely in this way for the first time since, you know, the Rome Conference, or you know, the water courses in mid-1990s and immunities in early 2000s. Politics are sometimes even odder than law, I guess.
Yes, some quite surprising conjunctures in there. I wanted to talk a little bit more about sources, but perhaps we can save some of that for questions. In the interim, it's perhaps just worth underlining the complexity of the discussion here. So I suppose when we teach about the ILC's work product, the first point of departure is that just because the ILC says something doesn't make it law. ILC per se doesn't have this jurisgenerative capacity. We have to evaluate the text on its own terms and think about perhaps as raw material for a treaty, as in so many of these past cases, and perhaps future crimes against humanity convention. Or we have to think about it as perhaps reflecting on crystallizing custom over a long period of time. You've said tonight that there's a certain artistry even to that, right? Even to the way in which we read the different layers of the work product, how much weight we give to the operative parts versus the commentaries and so on. But it's also that the process that you've described, the to and fro between ILC members and then with the Sixth Committee. But it's, if we think about the process of developing international law, whether it's up the progressive development end or the codification end, there's something going on in the actual process of exchange and conversation. It's not necessarily in the pages of the work product only that we see this movement unfolding.
Absolutely. And I think if there's perhaps one takeaway, it is locating the ILC work perhaps more explicitly and consciously as part of this process, rather than a text that captures something accurately, you know, that we have to divine and interpret really as an important glimpse that has to be adjusted. I think that there are really, you know, so many layers in trying to understand what went into it and also what happened to it afterwards. It could be that these are things that are invoked by parties, that are cited by international courts, or they could be things that sink without a trace. It could be in very, very rare circumstances, the model rules of arbitral procedure were even sent back by the General Assembly to the International Law Commission. So I think that is absolutely right. I mean, there's perhaps, I mean, almost perhaps an academic point that is my day job after all. Perhaps the ultimate process of peer review. If you think about the plenary discussion as something that you have, you know, 33 very opinionated people who certainly want to have, you know, themselves sit on UN Web TV saying something particularly mean and witty about their colleagues. Then you have, you know, legal advisors of states who are usually, you know, perhaps quite confident in being the people who understand international law. But that if something survives the process of the savage critique in all those settings on its own, that is worthy of some weight. And I mean, I think that is also why states are wary, perfectly, you know, for perfectly good reasons, that domestic courts and international courts might be too hasty in putting in Google, what does the International Law Commission say about X? And then not necessarily looking at the commentaries, plenary debate, Sixth Committee, hit at the first link and say, well, this is customary law, ladies and gentlemen.
And now ChatGPT compresses that process even further, so your work product can be used in even richer ways. I want to open the floor, but before I do it, I want to give you the last word on perhaps whether there's anything else you'd like to share about what this experience has changed or reinforced or challenged in the way that you kind of think about law or do law in your other work as an academic or practitioner.
I mean, one point we already touched upon, it's really the multilingualism point, and perhaps, I mean, I think you probably in UCL kind of we pride ourselves, I think, as a sort of a fairly international bunch, you know, linguistically and otherwise bringing a variety of experiences, so not having the sort of monolingual parochialism that one associates with certain countries' international lawyers. But I think, so it's sort of the sense of the accessibility of materials, really the point that came through when I was chairing the drafting committee, the sense that on precisely the same issues, the legal framing in English, French, and Spanish will be entirely different, even if engaging with the same ICJ materials as they are. So the way from multilingualism opens up a space for legal reasoning. You know, some rather encouraging things, really, again, perhaps, you know, UCL as being to some extent a fairly doctrinal international law school, a confirmation that law as law matters, that important and extremely busy people will devote a quarter of their year dealing with important issues of international law. That it does matter. It does matter for people coming from small states, from large states, from states broadly invested in status quo, invested in challenging it. International law is an important tool. So it, you know, sort of, it does exist. I mean, what was Crawford's line about kicking the stone? Samuel Johnson kicking the stone to refute the non-existence of reality. So it does exist. Practitioners have seen it.
A rousing point at which to invite others to a kind of contribution.
Possibly, I mean, also really the decentralized messiness, that the sense that international law is simultaneously true in its universal and in its regional, really the great strength of particularly practitioners from with experience in regional settings and regional organizations, bringing out issues that even a very, you know, studious and well-informed academic might not necessarily have helped with. And I think, you know, really sort of the generational thing of, you know, so the next generation of international lawyers helping us. And I think the appropriate moment perhaps to thank the UCL, the Weizmann International that helped, whose funding helped send 2 of our brilliant PhD students, Siu and Sean this year, and Gal and Yanwen last year. So it's sort of where the more and more visible College of International Lawyers, one hopes.
Thank you. Please do.